Welcome back. I'm Philip Bickle. This is Legal Tyranny, where I help to show you things that they would not teach you in 13 years of school. If you like this video, the content of it is something you think others would benefit from, please like, subscribe, and share. And let's try to inform others what's going on in these courts, that they cannot put any faith in them whatsoever. Alright, so let's pick up where I left off. That's part B of the argument section in my reply brief. I was ready to deal with the lack of jurisdiction and other potential issues that day, but I was made to enter a written motion instead, a later date instead. It wasn't my choice, as Appellee frames the matter, to continue making appearances absent the jurisdiction of the court. I was ordered to make one appearance after another under threat of arrest for failure to appear, even though no charges had been entered against me. Prosecutor Evan Smith had the opportunity to interject and enter the charges at any point during that hearing on December 15, 2016. Smith does this work for a living and should know that he is required to enter charges and how to enter them. The prosecutors had an entire year to schedule a hearing in which to properly initiate prosecution with the entering of oral charges. There's absolutely no excuse for failing to do so, especially when I raised the issue that the prosecutors had failed to initiate prosecution in my motion to dismiss. The record on appeal number 6 is cited there for evidence. How much of a cue is needed to prompt the prosecutors to perform the duties that the people of the state of Hawaii are paying the prosecutors to do? Rather than conceding this fact, the appellee attempts to enlist the enforcement officer for duties he is not authorized to conduct, specifically the initiation of prosecution of criminal offenses via the entry of charges. The appellee also fails to address the point that I raised in my opening brief regarding the insufficiency of the oral charges entered by Deputy Prosecutor Christopher Schloiter. I first raised the issue of the insufficiency of his charges on March 1st, 2019. And I'm being very specific with the places where I raised issue. I gave full detail for my objections to the insufficiency of the oral charges entered by Deputy Prosecutor Schloiter, including the failure to state required elements of the charges for violations of HRS 286-102 and 431 TNC 104. The appellee apparently failed to read my written argument for trial, which was suggested by Judge Freitas on March 1st, 2019. I very clearly indicate my reasons for demanding that any oral charges be provided in the common vernacular. Furthermore, I made my concerns clear on the record. So here's a little excerpt from this transcript. The citation does not have them in common vernacular, and it does not have a statement. Which part of the citation don't you understand that's not in common vernacular? I don't understand. I would like them to clarify which elements of the charge are legal terms. Let's put it that way. Okay, real quick on this. I actually stumbled across commentary between attorneys on some forum where there were attorneys, and apparently this can be a game in debate, asking people to explain something that they don't understand. But if you don't understand it, how can you explain what you don't understand, right? Okay, so I didn't know about that at the time, but it didn't feel right when he asked me that. It felt like he was asking me something that was ridiculous for me to try to answer, and this was before I realized it could be apparently a little bit of a debate, team sort of tactic to derail somebody else. Now, I'm not formally trained in debate, but I am, have engaged, my personality is Myers-Briggs INTJ, so very logical and intuitive, and somehow I managed to sidestep that. But if they try to get you to do something like this, explain something you don't understand, rephrase whatever you're doing, and ask them to clarify. So put the ball back in their court. Don't let them put the ball in your court when it's not something you understand. How are you going to move forward on that? They're going to make you drop the issue because you can't put it into terms. Okay, moving on. The discussion following this point shows that Judge Freitas refused to make the prosecutor clarify the language so that it did not contain any terms of art, which a layperson would not know. In fact, the judge insisted that was why I should have hired a public defender. But I am not required to forfeit one right, to handle my own legal affairs, or select counsel that I trust in order to practice another right, to be informed of the nature and cause of the proceedings. Okay, so I think it might be the Fifth Amendment. I'm tired. I'm really sleep deprived right now, but it's either the Fifth or Sixth Amendment guarantees the right to counsel. Well, I have a right to counsel that I trust, and I don't trust any of these bar members, and I have good cause for that. Furthermore, you have a right to be informed of the nature and cause of the proceedings, and judge cannot make you forfeit the right to handle your own legal affairs or select your own counsel just to be able to hope that you're properly informed of the nature and cause of the proceedings. You get a public defender, if you really think they're going to inform you, they're going to remove the legal jargon here, they're not going to. They won't even tell you that. This is why you have to learn certain basics of law. And in fact, never hire one of these guys unless you're in a position where somehow you can actually get something useful out of them. And if possible, hire them as co-counsel. You don't want them being your representative. You don't want them speaking for you. You want to speak for yourself, but have them do some of the grunt work. Go get this case law, go look up this, look up that. They are supposed to be doing those sorts of things, but many of them carry caseloads like 20, 30 people at a time, and they're not doing it. They're just handing out pleas here and there. But do what you got to do, especially if you're in jail. But yeah, definitely be careful because they'll bilk you. They'll make you pay for these guys when they don't do anything. Okay, the record on appeal shows that this document, written argument for trial, and the certificate of service on the prosecutor was filed with the court on March 23rd, 2019. That's 3 weeks before the second day of trial on April 12th, 2019. The appellee has had months to become familiar with my reasons for requesting that the charges be entered in the common vernacular. I had a right to be given the charges in terms that I could comprehend and not in legal terms of art that might have had a different meaning than what the layperson would know. It is my belief that the charges entered on March 1st, 2019 included legal terms which a layperson would not know, and as a result, I was not fully informed of the nature and cause of the proceedings against me. The appellee fails to acknowledge that the oral charges and arraignment on March 1st, 2019 occurred minutes before the trial began, and that they were very clearly amended from the insufficient charges entered on January 4, 2018, which did not give me a fair chance to prepare a defense based upon the elements of the charges that I was hearing for the first time about 840 days after the day of the alleged offenses. The judge and prosecutor Downs actually had the nerve to pretend that the oral charges entered on March 1st, 2019 weren't amended from the ones entered on January 4, 2018. That's a correction, 2018. There's absolutely nothing fair about throwing a defendant into a trial within minutes of reading charges into the record, particularly when I had made countless filings since the beginning of 2017 indicating that the prosecutors had failed to initiate prosecution. If they had provided sufficient charges in a timely manner and allowed me an opportunity to prepare a defense, I could have adequately prepared for the motion to suppress evidence, which hearing was held before any sufficient charges were entered against me on October 25th, 2018 and December 7, 2018. So this is very big. How can you prepare a motion to suppress when you're not given the charges that you're going to be dealing with at trial? I didn't have those. So this alone, I mean, when I tell you all, I have a slew of independent things in here that could alone get everything reversed, and everything would have to be dropped against me at this point because they can't. It's past the statute of limitations. They can't re-enter things. Can't do it over. But this, this is one of those standalone things. If they did everything else right, but didn't do this right, didn't get you the charges to work with before you had to prepare a motion to suppress evidence, then they're supposed to reverse. I would have had time to plan my questions for cross-examination, knowing what all of the allegations were going to be against me. I was given no time to prepare a defense based on these new and amended charges entered against me on the same day as the trial. This whole affair makes the notion of a fair and impartial judge presiding over my hearings a laughing matter, along with the thought of a fair trial. There are numerous violations of due process mentioned here, any single one being grounds to reverse the judgment and sentence imposed by Judge Freitas on April 12th, 2019. Okay, so this video is quite a bit lengthy. I don't know if I'm going to chop this thing up in the middle or not, but anyways, if you liked it, give it a thumbs up. Select notifications if you want to find or hear more videos like this, and share it with other people. I'm really counting on you guys to share this. If you're not sharing this with other people, you're not really helping. You're part of the problem. You got to share this with other people. And, hopefully some of you are on forums and sharing this on forums, because there's a lot of people that have no direction. They're trying to learn. Help them. Give them a little bit of a shortcut. This information in here will let people in the 50 states of the U.S. know, where procedurally these people are violating due process. And they'll be able to put something together for their own state, and hopefully, in turn, they'll post it so that other people in their own state can learn. Let's try to make this easier on each other, because it's a, intellectual bank. These lawyers are just, they may not all be the brightest, but they are sharper than the average person, and are all working against us. They, may feign as if they're there for you, like the public defender, but they're also known as the public pretender for a reason. So please share this, get it out there, and until next time.